The state of New Jersey's new concealed carry law, which defied the Supreme Court's Bruen decision, was just struck down once again. So let's talk about this. But real quick before we jump into this video, if you think it's time for the Supreme Court to once again strike down all of these concealed carry laws, go ahead and hit that like button and subscribe. Also want to thank the sponsor of this video, which is USCCA. Through your membership, you get training, education, and self-defense and liability protection. And right now, if you actually sign up for a membership, depending on what membership you choose, you can get a variety of gifts that they're giving to you for free with your membership, like this USCCA survival kit, which has like a flint and other things in it. You can even get a Pelican case, this vault case, along with backpacks, duffel bags, and other items as well. So I highly recommend USCCA. I actually have their membership. I've paid for it for myself, for my protection and for my family's protection. And again, if you sign out right now using one of the links down below in the description box or the comment section, you can actually get one of those free gifts along with your membership. So as I mentioned in the intro, in this video, we will be discussing the state of New Jersey's new concealed carry law, which was just halted by a federal court judge once again. The case we will be discussing in this video is called Siegel v. Platkin. In this case, a temporary restraining order was just granted by a judge, and the result of the TRO is that various aspects of the New Jersey concealed carry law is now blocked as unconstitutional. This case results from New Jersey passing a bill called A 4769. This bill was introduced in direct response to the Supreme Court's recent ruling in New York State Rifle and Pistol Association v. Bruen. This bill in New Jersey will change various aspects of the current New Jersey concealed carry permit process. The legislation requires gun owners who want a permit in New Jersey to purchase liability insurance and also to take a longer training course. It would also prohibit concealed carry on private property unless the property owner actually allows it. In the lawsuit, the plaintiff sought a temporary restraining order to halt the enforcement of this law because it violates the Second Amendment and also that Supreme Court Bruen decision. This case was consolidated with another case which also challenged the state of New Jersey's law, and that case was the Coons v. Reynolds case. We've talked about that case in the past in a prior video. In the Coons case, a district court judge, Renee Bum, granted a TRO against the state of New Jersey's new concealed carry law. In that order, the judge stated, defendants pressed this court to refrain from acting urgently and to afford them more time to set forth the legal justifications for the legislation. State defendants argue a hasty injunction would short-circuit the democratic process while the litigation process is underway. She went on to state that this court concurs in that no injunction should ever be hastily issued, but defendants must do more than promise they will justify the constitutional basis for its legislation later. Surely defendants had or should have had the historical materials and analysis that state relied upon when it began the legislative response to Bruen. After all, the Supreme Court was clear that in order for any gun control legislation to pass constitutional muster under the Second Amendment, such legislation must be consistent with historical tradition. The state has had 6 months since Bruen to identify well-established and representative historical analogs. She went on to state that, certainly, defendants anticipated challenges to the legislation and should have been better prepared to defend the legislation's constitutionality. So in the original Coons decision, the judge is outright denying the state of New Jersey's arguments that they will present historical support sometime in the future, but that they simply need more time. Instead, the judge is saying that the state should have had that evidence already ready to go and available before they even passed this law and before they even started to litigate this case, because they knew lawsuits would be the result of the law that they just passed. In that decision, the judge walked through the sensitive location restrictions that were present in the New Jersey law. She found that the public library and museum restrictions were indeed unconstitutional. She also halted the enforcement of the concealed carry law at any location that serves alcohol and all places of entertainment as well. She also found that the state's catch-all carry ban sweeps way too broadly and flips the right of concealed carry on its head. She in fact stated that private property owners have always been able to deny access to people, but then to say you as a law-abiding person have to ask permission or have the owner give you permission every time is not what the law historically has required. And what this does is it restrains the Second Amendment to a right only to carry on public property, which historically is not correct. So that was the basis of the original decision in Coons. Well, this case, Siegel, which we're talking about, was then consolidated with that Coons case and then sent to this very same judge. An expansion of that TRO was then sought and, in fact, was just granted by this same judge, this district court judge, Renee Bum. And again, she delivered us a major win. She, in fact, granted a TRO against New Jersey's restrictions, which restricted carry at parks, beaches, and recreational facilities, public libraries and museums, bars, restaurants, and other places where alcohol is served, entertainment facilities, casinos, private properties, and also the ban on concealed carry of functional firearms within your own vehicle. So that is a solid win. However, there was also something else really interesting that actually happened in this case. In this case, the president of the New Jersey Senate, Nicholas Scutari, and the Speaker of the New Jersey General Assembly, Craig Coughlin, sought to intervene in this case as defendants and to defend this law which was passed. Well, Judge Bum did in fact grant their motion to intervene, but at the same time, she likely made them immediately regret their decision. In the order granting that motion to intervene, she in fact stated, "At the same time, the court implores the presiding officers to focus their argument on the legitimate legal issues pending before this court after the clear dictate from the United States Supreme Court in New York State Rifle and Pistol Association v. Bruen. The presiding officers note that they intend to provide perspective on the critical public health, safety, and welfare issues that led the legislature to enact Chapter 131. But the Bruen court expressly stated that the government may not simply posit that the regulation promotes an important interest in the Second Amendment context. Instead, the government must demonstrate that the regulation is consistent with the nation's historical tradition of firearms regulation. The presiding officers must keep this litigation progressing on the right track. All agree that violent crimes involving firearms are tragic, but the dictate of Bruen is clear. Legislative interest balancing is understandable and elsewhere appropriate, but it is not deference that the Constitution demands here. While the legislator may disagree with Bruen, it may not disobey it. That language right there is the epitome of being careful what you wish for. The judges told these new defendants that of course they can join into this case, but they must only present relevant history and tradition which actually supports their law. The judge will not take into account balancing of interest or public interest arguments, since the Supreme Court in Bruen clearly stated that those types of arguments are irrelevant. So this is all another major win. You have a judge in New Jersey striking down a concealed carry law that was passed in direct defiance to Bruen. She also clearly is indicating that she will not consider any of these lame balancing of interest arguments or public interest arguments that states like New Jersey have used in the past and are still trying to use even in this case. Instead, she is sticking to what Bruen said, which is the only relevant analysis is going to be text as informed by relevant history and tradition. So this is a solid win. Now we will have to wait and see if a preliminary injunction will indeed be granted by the judge. The odds are that it's likely going to happen. So again, a big win. And if we get any more information, I will let you all know. So if you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.